this session is called What's the session called?
Sorry, Jean-Paul? Yes. Thank you. Yes, 2.5 years ago. Yeah. Turn phone off, that's important. Good.
Just give me 2 seconds. There we are. Okay, shall we give them a couple of minutes to pile in?
Yeah, I just think we should.
Yep.
We should.
Oh, you want to start?
No.
Give them a couple of minutes.
Give them a couple of minutes. Always give them a couple of minutes. This is not the easy. Well, it's not the most prominent
venue. No. Well, it's
venue.
actually often.
Well, I've never been in this room actually.
It's
before.
a good venue. I quite like it. Yeah. But yeah, it's a bit harder to find than the Brafani. Yes, elevates. Yeah. Okay. Too much echo. Okay.
This is a subject where it is very well worth stressing to people that it's a good idea if they introduce themselves before they ask a question.
Yes.
I mean, I'm sure you do that as standard anyway.
No, this is a good reminder.
This is a subject where most people don't feel strongly, but a very small proportion of people occasionally do, and it's well worth knowing where they're coming from.
Precisely. Yeah. I'm hoping we have a Google person in the room.
Sorry?
I'm hoping we have a Google person in the room.
Let's see.
Okay, shall we start? We're 5 minutes.
Yeah, fine. Absolutely fine.
Okay. Hi, everybody. Thanks very much for joining us here this morning. I realise it's a beautiful sunny day in Perugia after some rain, and as I understand it, there was a lot of activity at the Hotel Brufani Bar last night, so those of you who were there and managed to drag yourself to this session, well done. It is a really, I think, important conversation, and a conversation that needs global amplification. So thanks for being here, and thanks also to the people who are participating online through the live stream. My name's Julie Posetti. I'm the Head of Digital Editorial Capability for Fairfax Media in Australia. I also have a significant interest in press freedom and freedom of expression issues, partly as a result of being a research fellow with the World Editors Forum and WANIFRA, and also as the author of a forthcoming study on the protection of journalists' sources in the digital age. And there are many issues which relate to this discussion where there is overlap. So we have two significant panel members with profound expertise in this area. I'll introduce them to you in a moment, but just to give you some background to the topic, I mean, this session is, should we actually forget the right to be forgotten? That's the question we're posing. So the question is, is there such a right? Should it be declared a right? And that's something that the European Commission and the European Court of Justice have agreed, have ruled, is a right. And that's the reason we find ourselves in this situation, as the ramifications of those recognitions and judgments creep across Europe and start to have effects in regions outside of Europe. So the essential concern from a journalistic and freedom of expression position is that the right to be forgotten has a chilling effect on freedom of expression and on our right to access information. Sitting to my right is George Brock, Professor George Brock, who is a former editor and the author of this book, Handy Flyer, out of print. He's also the author of a major forthcoming study on the right to be forgotten for the Reuters Institute. and he's going to be talking to that report, I imagine, or giving us some insights into that report. George is a professor at the Department of Journalism at City University in London. As I said, a former editor and author, and he's also a trustee of the Bureau of Investigative Journalism. And sitting to my left from the Committee to Protect Journalists is the EU correspondent for CPJ, Jean-Paul Marthoz. I hope I've pronounced that vaguely appropriately. Jean-Paul is a Belgian journalist. He is a long-term freedom of expression and press freedom activist. He also teaches journalism, and he's a columnist for the Belgian daily Le Soir. So, in fact, I should also mention that he's the author of this report from CPJ called Balancing Act, where there are some parallel themes. So there's some resources available online, and one of them that I think you should acquaint yourself with is an Article 19 position paper which George was kind enough to share with me. I'm just going to, by way of introducing the topic, read to you from Article 19's policy briefing on the right to be forgotten. They state that it usually refers to a remedy which in some circumstances enables individuals to demand from search engines the delisting of information about them which appears following a search for their name. It can also refer to demands to websites' hosts to erase certain information. It's been considered as a right of individuals, rather than corporations or other entities, to determine for themselves when, how, and to what extent information about them is communicated to others. So for those of us who are familiar with the right to access to information and how those sorts of laws allow us to do journalism, and rely on access to historical public documents, you can see the implications. I won't go any further into that, but I'll share the link after this session. It's a policy brief from Article 19, and it includes a really useful 7-point framework for determining the response to the right to be forgotten legislation and policy. So I think we'll get straight into the discussion. George Brock is going to speak first, and then I'll move to Jean-Paul. I might ask them a few questions, but I want to engage you guys in the audience as quickly as possible. So if you can please start to think now about the sorts of questions that are in your mind about this debate. We'll come to you rather quickly in the discussion, and I'll get you to identify yourselves before you ask a question, so that for everybody we have a sense of people's engagement with this topic. So George, would you like to talk to us about your concerns and findings on this?
Thank you, Julie. Good morning, ladies and gentlemen. I'm here to try and persuade you this morning that this is something that journalists, the right to be forgotten, is something which journalists should know about, and indeed, in the current state of things, worry about. It's quite easy to misunderstand what's going on in the right to be forgotten, so I'm going to start without apology by just recounting very quickly how we got to the place we are at the moment. Some years ago, a guy living in Barcelona, Senor Costea, the case is usually known after that surname of his, complained to the Data Protection Authority in Spain that when anyone Googled his name, the top item in the search was the fact that he had in effect been declared bankrupt 12 years before over debts to the Social Security authorities. He complained that this was unfair and wrong. He took a case to the Spanish courts against both the newspaper that had published the news of his bankruptcy, and, this was the unusual and original bit of what he did, he took a law case against Google, who linked to that information. Very quickly, the Data Protection Authorities said, you have no case at all for obscuring or erasing what appeared in the newspaper. It was legitimately published. It's a fact on the public record. It's going to stay there. But you may, they said, have a case against Google. and they referred the case to the European Union Court, the European Court of Justice in Luxembourg. As there usually is in these things, there was then a long delay while the court thought about it, and eventually the court said, yep, you do have a right, an enforceable right, to ask Google to de-link the mention of your name under certain conditions, if certain tests get passed. That it is too long ago, that it is not adequate as a description of what occurred, or it is unfair. And in so doing, the court expanded considerably the right of data protection and, in some people's view, the right of privacy. I hope I have summarized it correctly enough for you to see that what the court was doing was allowing somebody to obscure a fact which was on the public record and perfectly accurate. When the case had first gone to the courts, Google had believed that they had a very strong case. It had been published in a newspaper. There was no question of libel or defamation. Everybody agreed that the original information was quite accurate. And they thought that they would be defended by the European Court. As it turned out, they were not. In the little world of data protection, and actually more widely, once this court judgment became known, as we say in English, all hell broke loose. People got very upset. Jimmy Wales of Wikipedia said this is a catastrophe for freedom of expression, and he wasn't the only person to have that opinion. Google, as this audience will know, has quite a number of issues at the moment with the European Union and the European Commission. There are some gigantic antitrust cases in Brussels right at the moment. So Google had a very strong incentive, even if they didn't like the court judgment in 2014, to cooperate. So very quickly, at what must still be, considerable cost, they set up a processing system for handling applications from people who wanted links to their name in Google searches to come down. The court had said nothing about how this judgment should be enacted. It just left everybody to find their way through it. Really, there were only two ways of doing it. One was that Google should do it, or that data protection authorities, there is a data protection authority in every EU state, because there is EU law covering this. But the kind of questions that were raised by the judgment were, if you can only know things now via Google, because there is so much information that is retrievable, you can only really know something via a search engine, is it an interference with freedom of expression to prevent Google linking to it? Another question which arises is, if this is a public issue, is it a good idea to have the first sift, the first judgment about delinking in the hands of a private company? Normally these things are done by public authorities. In this case, the role was taken by a private company. But obviously there were counter-arguments. People said, look, in the digital age, we have to adjust what we think freedom of expression allows and encourages. It is too easy to retrieve unfair, out-of-date, inaccurate information. There must be some chilling effect, phrase journalists like using, but in the other sense, there must be some chilling effect on inaccurate information. Otherwise, we will just spend our lives awash and haunted by, for years and years, wrong and inaccurate information. And another question that arose, although it didn't arise quite so quickly, was, are there going to be what we might call second-order effects of this judgment? In other words, are other countries likely to copy this precedent? The root of the problem that the court was trying to analyze lies in a directive about data protection which is passed in 1995. the current Data Protection Directive makes no mention at all of the internet. It was effectively written before the internet was in wide public use. It is about to be replaced by a new regulation which, I'm afraid, reproduces most of the problems of the old one. The difficulty with the Data Protection Directive, very shortly, is that it is very sweeping and it does not frame itself to balance freedom of expression and the right to know against the right of privacy. It tends, at least in my view, to privilege the right to privacy over other rights. And that has been a problem, I think, all along. I should say at this point, because it is becoming clear that I disapprove of what the court has said, that there was one undisputed gain from the court judgment. Google executives, since the court judgment, have acknowledged, have admitted, that there were things which you could search for on Google that they can't really defend as results. In other words, at the least, they were admitting that Google's algorithms are not perfect. You can be the victim of what you could call an algorithmic failure. I mentioned a moment ago second-order effects. There are a number of places in the world where the EU court judgment about the right to be forgotten was very influential, and the places where people, legislators and litigants have explicitly said we are following the EU precedent include Hong Kong, Japan, Korea, and in what I shall call less conscientious legislations, they have been extremely eager not only to copy what the EU court said, but to expand on it. The Russian parliament has recently published a right to be forgotten measure, and it contains none of the conditions and tests in the EU judgment, and I don't even think those are enough. I should just say, for historical completeness, in case there is anyone here today from that continent, that this issue was not made or created by the court judgment. There are many legislations about privacy in the EU, and particularly in Latin America, where the defense of reputation and honor and privacy include the ability to obscure or erase information which is both legal and published, and you don't even necessarily have to show that there has been harm. I think I'm going to draw myself to a close here. There are lots of issues that I haven't mentioned and that you may wish to ask me about in question and answer. In summary, I would say that it is not possible to say that the right to be forgotten has been a disaster for freedom of expression so far, but it has put into circulation certain risks and dangers, and at the very least, we have to be extremely alert to the problems that it can create, and I'm afraid that it has probably stored up trouble for the future. Thank you for your attention.
Thanks very much, George. Jean-Paul, can I come to you from your perspective, from a CPJ perspective?
Okay, just one remark. I mean, I fear there will not be much debate between George and me on this because I tend to share what he has
Furious
said.
agreement.
But just one detail. I mean, the Data Protection Directive that George referred to has been adopted yesterday by the Council. And there was a compromise that was reached in December last year with the Parliament, which means that next week, on the 14th of April, this data directive will be adopted without amendments possible at that stage, and soon it will become law and will be implemented as soon as it's published in the Journal of the European Union, just for one thing. Another thing that might help to understand why I shape the issue the way I do. As a young journalist, I was confronted with a law which had nothing to do with the EU, but with France, I mean, which had an amnesty law, which erased the condemnation of an individual from the public records, and didn't allow you as a journalist to mention the condemnation. So as a journalist, in my paper at the time, we decided that we would flout the French law, and because we considered that the condemnation of a public figure that had been erased from the books had no sense journalistically, even politically. So my philosophy, basically, is very much against that right to erase facts that, as George said, were accurate, were in the public interest, and were of course harmful to the person who asked for erasure, but erasing it would have been a violation of the European mission to say the truth. So concerning my own intervention, I would like to provide a context to the discussion. As you know, justice is highly politicized. I mean, as we just saw from the US Supreme Court debate today, where there is, after the deaths of Judge Scalia and the battle to name a new successor to Scalia, it shows that a Supreme Court is not, just a neutral body. It's really something which is highly politicized and can really have a powerful power to shape societies, even bigger sometimes than even parliaments. So I'm a bit, I'm part of, that crowd which analyzes the justice decisions in a political way. And so the decision of the Court of Justice of the European Union, which is based in Luxembourg, which has nothing to do with the European Court of Human Rights, which is based in Strasbourg and is linked to the Council of Europe, that decision was part of a number of battles that are explaining to some extent the way the European Union deciding to push for that norm in its own directive. First of all, even if the EU and the US are allies, they are highly competitors, in terms of a number of issues, not only in terms of our economic power, and there's a reality, there is a lot of resentment in Europe, to say the least, and I just quote James Cantor, who is the New York Times correspondent. He said a huge level of resentment in Europe regarding the domination of US companies in the field of internet and other related industries. And so there is really something which, to some extent, pervades the whole debate on those issues. It's the fact that some in Europe would like to establish a better field, more balanced field, in order to be able to develop a European industry and a European capacity that field. It's what the Wall Street Journal called a war between the EU and the US when it comes to those companies, and even sometimes the US media interpret some decisions taken by the Commission, like the antitrust investigations taken by the European Commissioner for Competition, Margrethe Vestager, as politicized, as being part of this anti-US agenda. I don't believe it's so much as the US media would say, but there's something in it. But also another issue beyond the economic discussion. It's the issue of the fact that the EU wants to be and presents itself as a normative power, and as George mentioned, there were, to some extent, ripple effects of the right to be forgotten decision in a number of other countries, and the EU sees that as great, as beneficial to its own soft power around the world. And so there's a clash. I don't know whether there's a clash of civilizations, but there's certainly a clash of legal norms and doctrines between the US and the EU in a number of issues, and there is a fear in part of the European Union circles that the concept that the US has in terms of free speech, and in fact that a free speech trumps privacy, would seep into the European system and might, to some extent, destabilize the kind of equilibrium that has been reached to some extent, mostly through the rulings of the European Court of Human Rights on issues of free speech. So there is this fear that has been expressed, for instance, at the judgment against Yahoo a couple of years ago in a French court condemning Yahoo France to take down advertisement for Nazi material on the web after a complaint from a Jewish student organization, and the French were absolutely strong in establishing the fact that Yahoo should be responsive to the French law and not to say, no, we are based in the US and we should be liable to the US legislation. So that's one issue. Another issue, you have a battle in Europe about the prerogatives among the various institutions. The Court of Justice of the European Union has been taking in the last years a growing presence in the absence of in the absence of a very strong strategic vision of the Commission or of the Council. The judicial institution, which the Court is, which is limited in its mandate to intervene on cases of EU law only, has tended to, according to a number of our lawyers, to go too far. And so, for instance, there was a report a few days ago published by a judge at the court who said, there's an issue here. The Court of Justice of the European Union is really going too far. And he said, I just mentioned him because it's part of the discussion about the right to be forgotten as well. It was triggered, by the way, by the discussion on the right to be forgotten. And the judge published a report in a think tank in Brussels, the Egmont Institute, and he said, he was referring to the exceptional legislative power that has been conferred upon the Court of Justice. One searches in vain to find an equivalent in the member states. Supreme courts do not enjoy a right of legislative initiative, let alone a quasi-monopoly over it. The events of the last 4 years tend to show that serious consideration ought to be given to the withdrawal of this exorbitant prerogative. So there's a battle between institutions. And anything that the Court of Justice does is part of that battle. And then there's a battle between European institutions, not linked to the EU only, but also to the other institutions in Europe. And there's clearly a battle between the European Court of Human Rights, which is linked to the Council of Europe, and the Court of Justice of the European Union on a number of issues. And in December 2014, for instance, although the Lisbon Treaty forces, the Lisbon Treaty, obliges the European Union to accede to the European Convention on Human Rights, the Court of Justice of the EU refused that and said that the accession would give an external body, meaning the Court of Human Rights, which is not linked to the EU, the power to decide upon the application of EU law. And so you have all those discussions taking place, plus a political discussion which is related to the power of private companies to act as quasi-common carriers or gatekeepers or private censors at the expense of the traditional role exercised by state authorities. And it is an issue that divides the European Parliament, it divides the Commission between, in a few words, between, I would say, the left wing and the right wing of the Parliament, or between the Liberal Party, for instance, in the Parliament, which doesn't have that much to say about the role of private companies assume that role, and the Socialist group, the Green groups, the left-wing groups. So you have all those issues that are interlinked and explain to some extent the highly politicized, but also highly symbolic nature of the discussion about the right to be forgotten, because many people think that it's just it's an issue which is at the core of the definition of what Europe is all about. And then a final remark, and I agree with George that journalists should be aware of the dangers that the right to be forgotten signifies for the exercise of our trade, of our profession. But which is strange is that in last years, since the adoption of this ruling by the court, I haven't heard from journalists that they were to some extent hampered by that ruling. For instance, there has been a high mobilization of journalists in Europe against the trade directive, the trade secrecy directive, for instance. And so it was blocked after mobilization of trade unions of journalists, association of journalists, free speech, and NGOs and everything. But on the right to be forgotten, the unions of journalists in Europe seem to be fairly, either unaware of the consequences or don't take that as a priority. For instance, I received a note from the European Federation of Journalists a few days ago and asked them, have you heard of any complaint from new members? And I had an answer, we didn't hear any complaint from any members. So that's why it's interesting to really try to understand why it can it is a threat for the exercise of journalism.
It's an interesting point. I wonder whether determinations are being made at a corporate level inside media organisations where historic documents or historic URLs, for example, are being taken down without necessarily communicating that to journalists on the ground in the newsroom, and whether that is what is leading to a lack of reporting. George, in your research, what have you uncovered about the rate at which takedown orders essentially are being issued? And is there any evidence that Google is, as Jean-Paul highlighted from earlier in your career, an independent newspaper took a stand not to adhere to certain legislation? Is there any pushback from Google? Are they flouting this legislation? Is that why we're not hearing about takedowns?
No, they're not flouting the legislation. They have fought one or two bits of its interpretation. There has been a row between Google and the French Data Protection Authority about the geographic extent of how far these takedowns should go. But Google is in the weaker position here, and they have just conceded, actually, that they can't confine these takedowns to the European domain, and they did that when the French Data Protection Authority threatened them with what would potentially be enormous fines. They have taken down about 1.3 million in round numbers URLs.
That's huge.
As far as we can tell, and I heavily underline that phrase, as far as we can tell, a fairly small proportion of that is probably journalism. But one of the major difficulties here is that this is an entirely untransparent process. There is no form of review of what is going on unless somebody gets to know what is happening, objects, and takes it to the National Data Protection Authority for review. So you've got to be very well informed to even get to that point. As far as it does concern journalism, and after all, the matter of rights is not just a matter of scale, Jean-Paul was saying, and I contest this slightly from the British side, because however much Britain might be an outlier in these things, there are a number of media organisations in Britain which have protested very strongly about this. The BBC is maintaining a list of the URLs which it knows have been taken down.
Is that publicly available, George, that list?
Yeah, it's a publicly available list.
And
it's the subject of a great deal of complaint. A lot of people think that this is, may not be technically against the ruling, but it is at least against its spirit. It is perfectly possible that a media organisation, and it would be high odds that it will be a British one, will take a strategic case in order to try and check, if not necessarily undo this judgment. And to pick up a hint that Jean-Paul dropped, it's quite likely that this case will not be taken to a national court and then to the European Court of Justice, but to the European Court of Human Rights. These two courts have so far managed to avoid colliding. This possibly may be the first issue on which they would collide, because it is quite possible, it would of course depend on the details of the case, that the European Court of Human Rights might take a different view.
In terms of weighing those
in terms
competing
of
values
weighing
of
the
privacy
rights involved. I mean, if you come from my point of view, the European Court judgment is a problem because it is a very strict interpretation of an existing piece of EU law. There is another approach, and it was taken by the courts. The European Court has a system under which an advocate general gives the court an opinion before the final judgment. And quite often the final judgment does not exactly copy, but follows the Advocate General's opinion. And in the Advocate General's opinion in the Costea case, the Google Spain case, the Advocate General said, this is a broad rights balancing question. There is a privacy right, there is a free expression right, we have to weigh these two in the case of this, and he recommended to the court that it should not take down the links. The court not only ignored everything that he has said, but made absolutely clear in its judgment they thought the Advocate General was going far too wide and asking the wrong question.
So George makes, sorry, would you like to respond to that?
No, I just wanted to add something. I mean, the clash between the European Court of Human Rights and the Court of Justice of the European Union is happening and will be increasingly an issue. But also the problem is that the European Court of Human Rights in the last years has, to some extent, become less defensive of journalists' rights in relation to privacy rights. I talked to the former vice president of the court the other day, and she was telling me that there's a real danger that the questions like reputation, for instance, become an issue which will trump journalists' right to know. So we're not necessarily on the safe way, I mean, to more respect for the right to know and journalists' rights on this, unfortunately.
Sorry, excuse me just adding in, but this is the appropriate moment to say the EU set up data protection and the privacy protections in it in order to try and have the same regime for everybody. But there are 28 states in the European Union, and the way that a particular society balances privacy and freedom of expression is usually something that a state has worked on over centuries. The legislative balance is a very delicate thing, and different societies in the EU see these issues in quite different ways. For example, since the big European Court decision, 3 right-to-be-forgotten cases have come up in front of Dutch judges. On every occasion, the Dutch judge has, without saying so out loud, implicitly criticized the European Court by handing down a judgment that very tightly restricts the ability to get things delinked from Google. In each case, the different Dutch judges have said, you may think you can come to this court and just ask for a URL to be taken down that you don't like, but actually you can't. There are tests you have to pass. That would also be the attitude, I would guess, probably in most Scandinavian countries, and where these have come to courts in the UK, that has mostly been the case. But the tradition about data protection and privacy and honor and reputation in Germany, France, Spain, and this country are entirely different traditions, and judges will not behave the same way.
Indeed. I recall a conversation with an Austrian diplomat just last year in the context of a UN experts consultation on source protection and whistleblowing, and this issue came up at dinner. And as the Australian who inherited a UK tradition of and law and focus on freedom of expression rights balanced against privacy, where criminal records, for example, are absolutely a matter of public record, and they are very rarely quashed, very rarely sealed, apart from, say, children under the age of 16. You know, there's these sorts of exceptions. So to me, it made absolutely no sense that there would be any case in the context of freedom of expression for the right to be forgotten to find currency among civil society, among activists for human rights and freedom of expression, and yet it does. And he stopped me in my tracks and said, well, in Austria, the judgments are not necessarily a matter of public record. There is a view that if you have been convicted and you have served time or there's a penance, then you have a right to be forgiven and, you withdraw. So these are interesting cultural distinctions. I just want to take it back, though, to the practicality. I'm thinking, so George made the point that only perhaps a small number of the URLs that have been taken down are journalistic product, but we can't...
We think,
but we can't take our minds off the fact that what constitutes journalistic product now, especially in the age of mass data journalism, that all of the data that, for example, the Panama Papers have relied on, the most extraordinary leak-based story in journalistic history, as far as anyone can tell, all of that documentation that is then put online. Imagine the clamour of the implicated to have those documents and the journalism that has been produced from those documents to be pulled down. So. In the context of the Panama Papers, Jean-Paul, as a journalist working in this space, do you have concerns that we might see that sort of clash occurring as journalism is more collectivized now. We have citizen reporters also accessing documents that the reporters on the Panama Papers, for example, have released. You know, the data mining can happen collectively. So when you remove URLs that may not be journalistic in terms of output but can lead to journalism, what is the risk to journalism of that scale?
The paper I work with was part of the Panama Papers investigation, and we had a battery of lawyers with us, first of all, to make sure that there was no defamation case, because the laws are so different from one country to another. We were afraid of libel tourism in the UK still, although despite the reform. But yes, I mean, the only journalists that I have heard really being nervous about the right to be forgotten very often are investigative journalists that are, personally, I mean, just when I was speaking about the journalists' lack of awareness, apparently I was just reflecting the views of the Association of the European Federation of Journalists, but in my own kind of work, I mean, there's something which journalists are aware of. Anything that might hamper their access to information is seen as a threat, but they don't necessarily specify the right to be forgotten as the first issue in their fear. I mean, the other threats that they consider might impair their work. But it's true that something which, for instance, when I was talking with a friend of mine who was an investigative journalist working on the Panama Papers, and I was just mentioning, I'm going to talk about the right to be forgotten. And he said, okay, good luck. And I said, are you aware of it? Yes, I am, but I've never find it as a major problem at this stage, because I know about it and I know how to get around it. If I have no answer, no result, I mean, under a specific name, I will find a way to get access to the articles that have not been removed, as the ruling said. I mean, La Vanguardia was able to retain in its archives the article that was at the basis of the complaint. So it didn't seem to be too nervous, but he said, anyway, I mean, the problem is that if you allow the European Union to have this kind of directive, I mean, it opens up the door to other kinds of measures that might be perhaps more aggressive against journalism. So this is how they put it. I mean, it's not as a direct threat today, but as having a sense that it might reflect a philosophy within the European Union institutions that there are some areas that the journalists shouldn't know about, or some information that should be close to the public. And it was why, I mean, basically the Trade Secret Directive was such an issue in Europe among journalists. But I take that Trade Secret Directive and the right to be forgotten to belong to the same family of threats against journalism.
We could take a perfectly specific Panama Papers case and imagine it. You are a person whose name has appeared in the Panama Papers. It is on the website, the documents are on the website of Le Soir. You can apply to Google to have the link under your name taken down. Now, we rely on Google to say, no, that has been published in the public interest, and we think there is a public interest defense to that URL remaining. But if a search engine, and other search engines do this too, although they're not, we don't think they're explicitly obliged to at the moment, if the search engine takes the other view, that process is not automatically contestable or reviewable. The URL might just disappear.
Absolutely.
So let's go to you in the audience now. Do we have questions? Does somebody have an observation or a question? Yeah, whoever has the microphone, there's a man here towards the back. Just remember to tell us your name and where you're from, please.
My name is I'm with Correctiv in Germany, and I'm also maintaining, for example, the database about farm subsidies in Europe. And we occasionally get takedown, so the information from Google Search Console that a link has been removed due to the right to be forgotten. And I'm also...
Sorry, could I ask you to do two things? Could I ask you to stand up?
It's a bit tricky, but...
And could you talk at about half the speed? There's a lot of noise from outside.
Yeah, yeah.
All right, so I'm with Correctiv, a non-profit in Germany, and I'm also maintaining the farm subsidies database, like a website, farmsubsidy.org, where we collect who gets farm subsidies in Europe. And we occasionally get takedown, so notices from Google that links have been removed from search results. And we also publish lots of databases about public figures. And we do this in order for them to appear in Google, because the people don't search our databases, they search Google when they want to find something. And so I'm wondering, should we have something like Lumen, like the chilling effects database in the US, that lists DMCA takedowns? I mean, the BBC lists their URLs, but do we need, as a journalism community, a database where we can submit these URLs, where they are like centrally searchable?
Well, you could certainly do that. The reason why that hasn't happened much is that the data protection authorities have very strongly taken the view in the EU that Google shouldn't do that. And Google is relatively easy to intimidate at the moment because they have, as we say in English, much bigger fish to fry at the EU. So it is very easy for the EU authorities to say to Google, we would really, really much prefer you say that you're being notified when they take these down. The data protection authorities have told Google that they would really like Google not to do that. So you wouldn't even know when the link has been taken down. In those circumstances, personally, I would just list them as your own organization. I wouldn't necessarily worry. The minimum thing you can do is at least let people know when a URL has gone down. That seems to me to be a minimum good contribution.
And perhaps summarize what it contained, if possible, if you are aware. Does anyone else have a...
That may just replant the whole issue, if you see what I mean. You've got to think a bit about how you do that, but yeah.
Sure. Any other questions from the audience?
Don't tell me we've all convinced you about this. It can't be possible.
I don't, there must be a contrary view. Has anybody had experience of being defamed and wishes they had the opportunity to request a takedown order, for example? Nobody is willing. I think we are all probably an audience in furious agreement, interested in preserving the rights of journalists to report. Would you like to respond to that question?
No, I have a question to George. I mean, really, it was just interesting. So, no, it's concerning the directive which is going to be adopted. I mean, how do you see? I mean, how do you see it? Because I mean, some people said this directive would help precisely to soften the ruling of the court and solve. I mean, meet the complaints and the reservations that some people had, some press freedom groups had, free speech advocates had concerning the right to be forgotten. How do you analyze the current ruling as it will be EU law in a couple of days?
There are indeed people, Jean-Paul, who have said that the new regulation which is about to be passed will do away with these problems. I don't think that is true. Firstly, it reproduces in almost exact terms the privileging of data protection and the privacy right under data protection ahead of all other rights. Look around the world. I will take, our chair is Australian, but if I may take the next door country, New Zealand, which has thought very hard about these issues. All the law in New Zealand is framed to say there are very important privacy rights, there are very important rights in data protection, but they are balanced against other rights, such as the right to know and the right to free expression. And therefore we must take each case on its merits. Now, they have tried in the new EU regulation to put in some cautions, but they have not really, in my view, rebalanced the basic pitch of the law. And I still think it is going to reproduce these problems, and they have introduced some new ones. The right to be forgotten appears for the first time in an EU legal text, and it provides for a power of immediate takedown. The the search engine, not the publisher, the search engine, and don't forget, some search engines are small and specialized and not gigantic businesses like Google, are required to take down very quickly a URL if it is complained about and immediately. And one of the we have been lucky so far that this has mostly been directed at Google. Google is a very large corporation with enormous resources. There are smaller search engines. As lots of people pointed out when the judgment had been made, a small search engine will just make very careful decisions. The one thing it can't afford to do is to be taken to expensive court cases. So there is a bias built in there, and I'm afraid some of this is reproduced in the new law.
We have a question in the front here.
It's a question for George, Corin Podger from BBC Media Action. You mentioned that the unions, the journalism unions, have a low level of awareness of the law, of the legislation. If there was better awareness of this legislation, what would you then want to see happen?
Well, I think ultimately there is a risk that this will cause a problem which will force the now brand new EU law to be revised again. We referred a moment ago, so I won't repeat the point, but I mean, if there is a collision between the European Court of Human Rights and the EU, that will almost certainly lead to some revision. I would prefer much more specific tests for takedown. I think the immediate takedown procedure that is coming in the new law is wrong, for reasons I explained just now. But above all, what I would like is the process to be sufficiently reviewable and contestable and transparent that when there is a public interest issue at play, we can see it and we can deal with it. The problem about the present process is that it's accidental. It's random. The Chief Privacy Counsel to Google had the cheek the other day to say, on the subject of the right to be forgotten, we are building up extensive and fascinating jurisprudence. Well, it's extensive and it's fascinating to him, but it's all being done in secret. The people who are doing, the paralegals who are doing this at Google are having an absolutely fascinating time. They are really building up a database that is completely unique about this. And we have no access to any of it. They give us the barest statistics. They keep telling us that they are working on a more compatible with the rights of privacy way of disclosing more about what they're doing, but it's very nearly 2 years since the judgment, and we're still waiting.
Do you have anything you wanted to add?
No, I agree with George. I mean, it really has created a chilling effect. I mean, you don't really have the right to be forgotten, but there's a feeling among press freedom groups or free speech groups in Europe that the right to be forgotten is just one example of a wider approach to all things related to freedom of expression and the balance between privacy rights and free speech rights. I mean, unfortunately, I would say I'm wrong, but at the same time, what is also part of what I mentioned at the beginning, this clash of legal civilization or cultures between the US and the EU. I mean, in the EU circles that I meet every day, they tend to exploit a lot the fact that the right to be forgotten, for instance, is being criticized mostly by Anglo-Saxon or US organizations and that try to sort of present an equation between privacy and free speech. So they don't see it as a discussion which would be quite open and intellectually open. They take it as a, if for instance I work with CPJ, which is a New York-based organization. I'm also vice chair of the advisory committee of the European Central Division of Human Rights Watch, which is a New York-based organization. When I talk to those circles in Brussels, although I'm a Belgian and very much pro-European, I have to say, I'm still considered to be the voice of a different power, I mean, with which the EU wants to compete on those issues of legal norm setting in the EU, but also around the world, and also, at the end of the day, considered to be a representative of the US power in the field of high-tech industries, which is not the way to address that issue, which is really an issue which gets at the core of the discussion about the delicate, but we have to discuss it and find out the balance between the right to privacy and freedom and the right to know and I tend to lean myself much more on the free speech side than on the privacy side.
Just one little
context.
point about rights, if I may. There is a right to privacy in most big instruments on human rights. There is a right to data protection in quite a lot of instruments of human rights, the major documents, although it's not in all of them. There is no right to be forgotten in any major human rights code anywhere in the world. And there's a reason for that, which is that if you're going to worry about what the retrievability of digital information can do and the harm that it certainly can potentially cause, you need a very specific remedy to a very precise problem. And human rights language is extremely broad. And it thus tends to lead to sweeping powers unless you're very, very, very careful about it. The internet scholar Jonathan Zittrain says that actually this discussion is going to be rapidly overtaken because in future the negotiations about URL takedowns will all be done by artificial intelligence. Both sides will be using robots.
Which is the theme of another session here. Just finally, there was a tweet sent to us by Stefan Conrath, who was originally was supposed to be in my chair, who, in response to my question around people's experience of perhaps defamation or the desire to have something taken down from the web, he points to a case of a woman who wants URLs that effectively caused the bullying of her son, who then committed suicide, to be removed. So I suppose, these are the nuances we're dealing with, and they're still there after his death. But for me, as an Australian sitting amidst Europeans, having spent some time living in Europe, it remains to me an issue of the right to remember, and from a historical perspective, especially on a continent that has made such significant attempts to remember the Holocaust and now is trying to remember, the Bosnian conflicts, for example, and the consequences of those. To have this discussion around the right to be forgotten is complex and nuanced, but very problematic. So I think we have to leave it there. We are being evicted. Thanks very much for those of you who participated today. Thanks.
No hanging around on these things. Thank you very much indeed.
Thank you. That was good.
Okay, so.
Well done. It was a really interesting